Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, your toaster's on the stand.
Welcome to the show, everybody. I'm Seth Nelson. As always, I'm here with my good friend, Pete Wright.
Okay.
Now, Pete.
Yeah, I'm nervous.
You're going to be the client today.
Hot pivot. I'm ready, and I'm an idiot. So we should be in great shape.
Okay. So here's the concept here. Andy, our producer, the man who's not allowed to talk on the show, said, Seth.
Yeah, but who runs the whole thing?
Exactly. The man behind the curtain. If you ever have anything that comes up in your cases, let us know because we should do a podcast on them. And I just recently prepared a client for a deposition and then trial testimony. And Kristen Scully, one of our great attorneys here at NLG, said, have you done a podcast on that? And I thought we did.
Yeah.
And I was mistaken because I'm never wrong. Sometimes mistaken. Okay.
But you're actually neither wrong nor mistaken because we did, but nobody's heard it because it was in our practice podcast before this podcast.
That's why. Well, it's nice of you to save me, but I'm about to put you through the ringer here. So that was very kind, but it's not getting you off the hook.
Yeah.
Okay. So this is one of the things that I think is critically important. And in my experience, a lot of lawyers don't do well, if at all.
Okay.
To set the stage, case hasn't settled and you're going to be deposed, which means the other lawyer who is paid to try to take your children and your money from you is going to ask you sworn questions. And these questions and your answers literally can be given to the judge in court and said, here's what they said. Here's what Pete said. So I spend a lot of time preparing my client for depositions. Let me tell you what I don't do. I don't write questions and then write the answers and have my client memorize them because you're not allowed to do that. It's called coaching in quotes, but you're allowed to prepare people. Okay. This is the preparation. You ready?
I am, I think.
Okay. We're going to start with the rules of a deposition. And the rules are this, Pete. You're going to listen to the question.
Mm-hmm.
You're going to think about the question. And this is the first decision point. If you understand the question, answer it honestly in the least amount of words as possible.
Okay.
And then shut the fuck up.
Okay. It's that last point we're going to need to review, I worry.
Yes. Okay. Listen to the question.
Got it.
Think about the question.
And is there a character I need to take under? Like, do I need to do some voice work or because
no, you are
okay.
you. You are the star of this show.
Okay.
Listen to the question. Think about the question. If you understand the question, answer it honestly.
Few words, honestly.
In the least number of words as possible.
And then shut up.
Then shut the fuck up.
Okay.
Okay. Now, there will be some exceptions to this down the road, but these are your rules.
Got it.
Are you ready to begin?
Yes.
Okay. Look at you practicing.
Yeah, I was just now. I almost said yes, counselor, but then I realized that's superfluous.
Right. Very well done.
Yeah.
Okay.
Yeah.
So we're going to practice. I'm going to say when I am in the role of the lawyer trying to take your money and your kids from you, I'll say, I'm the bad lawyer. Okay. I'm opposing counsel. Let's go. And then I'll say, okay, I'm Seth. Let's talk it through.
Okay. Good.
Here we go.
Perfect.
You're in a deposition. So a deposition, sworn testimony, no judge, just the court reporter, the other lawyer, his client maybe, you, your lawyer. Here we go.
Okay.
I'm the bad lawyer now. State your name for the record.
Peter Wright.
Pause. Seth here. How'd we do? A, B, C, D, or F?
I did exactly what I needed to do. I stated my name and then I shut up.
Okay, here we go. You got an F.
What?
As do all of my clients that go through this. You got an F.
That's so mean. This is so mean. Why did I get an F?
Okay, we're going to explain it. What did I say to you?
State your name for the record.
Okay, you're a smart guy, Pete. Is that a question?
Well, no, you just asked me to do a thing and you're an attorney.
I didn't ask you. I demanded. Nowhere in my instructions to you were to respond to demands or statements.
So what do I say in that case? You, bad attorney, please ask the bad attorney to come back.
Hold on. Still good attorney here.
Okay.
Southern.
All right.
This is the point. I gave you a command. So, of course, if you are sitting in the stand or in a depot and they say, state your name for the record, you're going to state your name. Because I, as the good attorney, am going to look like an idiot to say, objection, not a question.
Right. Okay.
And I'm good enough at looking like an idiot on my own. I don't need your help.
You don't need any help. Right.
But here's the point. Later in the deposition, the lawyer is going to say a statement such as, you don't manage money well.
That's a shut the fuck up.
That is a statement. And you do not respond because this is not a conversation. It's an interview. Questions, answer. Questions, answer. Got it?
That is I get it. I understand why I failed. I'm ready.
Okay, here we go. Start again. Bad lawyer here. Trying to take your kids and your money. What is your name?
Peter Wright.
Pause. Seth here. How'd you do? A, B, C, D, or F?
A. Totally A. You asked a question.
I did. What are the rules?
You're to answer questions. Did I understand the question? Answer the question in as few words possible, and then shut the fuck up.
Okay. Hypothetical here. I'll tell you. You got a B.
Oh my goodness.
Okay. Not an A. Yep. You got a B. Now, I want you to think back. Before you were dating your wife, who you love dearly.
Yeah.
And you're in a bar with your buddies. And a gorgeous woman comes up to you and says, you're very attractive. I would love to buy you a drink and get to know you more. What's your name? What do you say?
Peter Wright. And then I shut the fuck up.
No, you do not say
exactly
Peter
what
Wright.
would happen.
No. Tell the truth.
Play at this game. I would say Pete. Yeah.
That's right. You would say Pete. Now, why, when I told you your rules, did you say Peter Wright?
Because I'm in a courtroom. I'm in a conference room with a bunch of attorneys.
That's right. You're in a formal setting. And you answered formally. When I gave you the hypothetical in the bar, you're not in a formal setting. And you answered informally. Nowhere in my rules does it say answer formally. It says answer in the least number of words as possible and shut the fuck up.
And I gave my last name. They already know my last name. They're not saying, please state your name for the record. I should just say Pete.
That's the question. That's the answer. That's the answer following the rules. So let me show you how this plays out. Here we go. Bad lawyer again.
Mm-hmm.
What's your name?
Pete.
What's your full name?
Peter Damon Wright.
Good lawyer here. A+.
Okay.
A+.
Okay.
You've done two things very well there. One, you followed the rules on the first question. You did not help me do my job by giving your full name. You made me ask a second question.
Okay.
You made me do my job. Some judges will say, not all of them, I wish more did, Mr. Nelson, you have an hour for this hearing. You get a half hour. The other side gets a half hour. You just made that lawyer burn his time.
Okay.
Because he asked a bad question. Okay. The other thing you did very well when I said, what is your name? You gave your full name.
Mm-hmm.
Right after, like, you said, what's your name, Pete? What is your full name? I said, you gave your middle name.
Yeah, that's my full name.
That's right. But a lot of people miss the word full. They give their last name. And then I say, in my hypothetical preparing the clients, I say, do you have a middle name? Yes. Do you recall that you just answered your question on what is your full name and you didn't give me your middle name? They're like, oh, it's it's Damon. I'm like, no, that's not my question. So did you answer it honestly the first time?
So now you're questioning my credibility because I didn't say my middle name.
Right off the bat. And it just gets people shook.
Goodness.
And I'm doing that. And at this point in the prep, my clients are not feeling good or confident.
Yeah.
Okay.
No, I'm on a podcast and I'm not feeling good or confident.
Right. But here's the point. This is why we practice. You're in the gym lifting and your arms are sore. You're out running and you're breathing hard because the next time you do it, it's going to be easier.
Okay.
Very good job so far.
Well, okay.
Doesn't feel like it. Very good job because here it goes. Bad guy. What's your name?
Pete.
What's your full name?
Peter Damon Wright.
See, easy. You learn that in 5 minutes, but we spent 5 minutes on your name.
Yeah.
Right.
Right.
Right. Okay.
That's the embarrassing part. I'm actually wondering what my name is right now. Right. I'm not entirely sure that I know.
Well, you don't want to know what Andy calls you. Okay. So we've also learned that you don't respond to statements.
Yes.
Okay. I just did something there that I knew you were going to do. I said the phrase, we do not respond to statements.
And I answered, God damn it.
No, you weren't on the stand. We're just talking here. But I paused. And when people pause, people don't like the silence. And they start talking again. So you've got to get comfortable with the silence. A question is asked, and you answer. And when you shut the fuck up, that isn't shut the fuck up until you're uncomfortable with the silence. And start talking again.
You can't handle it. Okay.
Stop talking. It's their job now to ask another question. Make them do their job.
Okay. This is hard.
It is. Now, the other thing that's really hard is not to get defensive and not to try to explain a bunch of your answers. We've talked about it before. You don't get your day in court. Your lawyer does. Mm-hmm. But when you're on the stand, you think it's your day in court. And you think that if you just explain to the judge what's going on, everything's going to work out just fine and in your favor. I assure you that's not the case. So I'm going to give you a little break here.
Okay.
I'm going to have you play the judge.
Oh.
The point of this is when the other side gets done with their deposition of you, or if you're in testimony, when you're on the stand, when they get done with you, you should look bad.
Okay.
You should look bad. If they're doing their job and you're following the rules, you should look bad. And my point of this is that's why you have a lawyer, to clean it all up and tell a different story. Okay, here we go. You're the judge. I'm going to play the role of the wife's attorney. And I'm also going to play the role of the husband who's on the stand.
Okay.
And then we're going to pause. I'm going to ask you a question, and then we're going to continue the hypothetical.
Got it.
Sir, are you asking for 50-50 time sharing in this case? Shared custody? Yes. In the last 365 days, how many overnights have you spent with the children? 5. Has your wife prevented you from spending any time with the children in the last 365 days? No. Did you text your children at any time in the last 365 days? Yes. How many days? 5. Were those the same 5 days that you had overnights with them? Yes. Did you text them the other 360 days? No. Did you send them any mail in those 360 days? Yes. How many times? 12. Did you call them in those 360 days? No. And you're asking this court to give you 50-50 time sharing? Yes. Your Honor, Pete?
Yeah.
How do you rule?
Bailiff, please remand this man into custody. He's an idiot.
Okay. So I'm assuming you're not giving him 50-50.
No. I
Why?
would not give him 50-50 because he has not demonstrated any interest in having the kids more than 5 days.
There it is.
Yeah.
The assumption.
Right.
He has not demonstrated any interest. There was no testimony about his interest.
No.
But that's the assumption you've made based on the evidence presented, and a judge is allowed to make those assumptions. And good lawyers attack the assumption.
Okay.
Here we go. I am now husband's counsel. Husband's still on the stand.
And I am still the Honorable Pete Wright.
You got it.
All right.
Are you currently employed? No. Were you previously employed? Yes. Did you quit your job? Yes. Did you get fired or quit? I retired. What was your position? I was the commander in the U.S. Navy, and I was stationed on the Theodore Roosevelt nuclear aircraft carrier. When did you retire? Yesterday. Where were you stationed for the last 365 days? On the U.S. Theodore Roosevelt. How many, if any, days was the Theodore Roosevelt in port? 5. Where did you spend those 5 days? With the children. What did you do with them? Took them to the park, went to games, they had their extracurriculars, helped with homework. Did you text them in that time? Yes. Did you call them in that time? Yes. Where were you the other 360 days? It's classified, but the best I can tell you is I was out at sea. Did Theodore Roosevelt ever go into any port in those 360 days? No. When you're on the ship, are you allowed to make phone calls? No. When you're on the ship, are you allowed to text? No. When you're on the ship, are you allowed to send mail? Yes. How often? 12 days. 1 day a month. Where do you live now? I live in the same development of the marital home. I am 5 minutes away. Why did you pick that? I wanted to be close in case the kids forgot something, easy to go back and forth, and it's the same school district as the marital home. Are you asking for 50-50 time sharing? Yes. Can you implement a 50-50 time sharing? Yes. I'm retired. Your Honor, no further questions.
So at what point do you hear the Your Honor actually facepalm? Like at some point he's like, oh, like do you hear an audible sigh from the judge?
Only in my head.
Of course.
And when I give people the smoking gun document, I hear dun dun dun.
Dun, 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 yeah. No, that's suddenly, I totally get what you mean about attacking those assumptions because it's so easy to set up the assumptions, especially under the rules that you gave me. And so it's hard not to see this as just spinning time, right? Like just trying to burn through time.
What do you mean by that?
I mean, my gut is telling me when I'm being, deposed by my wife's counsel to explain more.
That's right.
To say all the things that you ended up getting out of me later. Wouldn't it just circumvent this whole back and forth thing if I could just get it all out?
No.
That's the frustrating part. I get that. Yeah.
Here's why. Is you think what you're going to say is going to solve the problems. And like, look, okay, the problem is on this fact scenario, it seems pretty obvious it's going to solve the problem.
Yeah.
But on a trial with 20 different factors, you're going to say something that's going to lead that lawyer down a path that he might not have known was even there.
Okay.
And you're not going to even see it. The other lawyer is going to see it and think, fuck, I told Pete to shut the fuck up.
Yeah.
You know?
Yeah.
Don't give him an inch. Make him earn it.
Got it.
Okay. And the same in court. Because you say something. Let me give you an example. Years and years ago, question in court. Sir, how much did you pay in federal income tax last year? Proper answer and truthful, honest answer, I don't know. Answer in court, I don't know. I haven't filed or paid my taxes in 4 years.
Noted. You can't handle the truth.
You know what the judge did on that one?
Huh.
Did not use a net income when determining child support because he said his gross income is his net income because he just testified he hasn't paid child taxes in 4 years. And I have no indication to think that he's gonna.
Wow. Okay.
So
significant.
Stop talking.
Yeah. Okay.
Right.
All right.
Now, the other point of this is it just seems so easy to defend yourself. But it's not your job. Your job is to be the witness, not the lawyer. The lawyer you've hired is to defend your case and tell your case and tell a story through objection-laden testimony. Okay? Questions so far?
I have no questions.
Okay. If you were following the rules, you just would have said no.
No, I would have said no. I knew it as soon as I said it.
Okay. Couple other things to be aware of. One, this is not a conversation. Like I said, it's an interview. question, answer, question, answer. The lawyer asks the question, the witness does the answer.
Mm-hmm.
You don't ask the lawyer questions.
So give me an example.
Sir, isn't it true that you don't take your kids to extracurriculars? You say, not to all of them. Well, isn't that true because you work really hard and you have a successful podcast business? Well, yeah, but it's probably same for you, right, Seth or Mr. Nelson? You're an attorney. You're working late hours. We're running late right now.
Yeah.
Right.
Okay.
Happens all the time.
I totally get that. What about questions like, would you rephrase the question or something like that? What if I legitimately don't understand the question?
I was going right there. Okay. Here's a question for you. What, if anything, positive you can say about subsection 61.13(3)(b) about your wife?
I don't know.
Right. What do you mean you don't know?
I mean, no, it's either no, I can't say anything positive because I don't understand section blah, 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 blah.
You can just say, I don't know. Well, why don't you know? And your next answer is, I don't know what that section is. Right. It's not, I don't understand the question.
Okay.
Because
just answer the question as presented.
That's right. You can say, I don't understand the question. That's perfectly legit. I don't understand the question. Well, what don't you understand? I don't know what that subsection says.
Again, making the lawyer work for it.
Make him work for it. Make him work. Okay. The other thing is, I just hate to say this on the show. You're a nice guy. Okay. You're a nice guy. Okay. And the other thing about you that people don't know is you're very helpful. You're a helpful guy. You like to help out your friends. And if someone calls you, you're going to be there. And even little things like if I'm having a problem with the computer and the camera, you're like, hold on, I can help you through that. Click here, click here, click here. You're very helpful. So that part comes through and you want to be helpful. And sometimes they're just asking bad questions and you think they know what they're trying to ask, but they asked it so poorly. You're just trying to be helpful. So you're going to answer it anyway. Well, now you've got problems because you didn't really understand the question. You thought you understood it and you thought it wasn't a good question and that wasn't what he was trying to ask. But on the cold, hard transcript, that's what he said. And that was your answer.
And that's what's reported. So when you say bad questions, it feels like there are two kinds of bad questions. One, because they're inept, right? Those are just terrible questions and they actually don't understand what they're talking about. But the other kind of bad question is a question that's designed to trip me up, like you said in the beginning.
Good lawyers will not have questions designed to trip you up.
Oh, okay.
They will let you trip yourself up all on your own.
Okay.
Okay. Here we go. I'm Seth, you're Pete, but I'm taking your deposition. Okay. Do you believe you're a good parent to your children?
Yes.
What, if any, qualities do you believe that you exhibit that reaches the conclusion, I'm a good parent? What characteristics? What did you do for your kids that leads you to that answer, I'm a good parent? See, now you're stuck because I told you to answer in least number of words as possible. Exactly. This is a softball, though.
Well, I'm present for all of their special events. I work an abbreviated schedule so that I can drive every carpool. I make their lunches every day and make sure they're well fed. And I read them stories every night and I do all the voices.
Have you ever had to travel out of town when the kids were school aged?
Yes.
And was it a morning that they had to go to school that you were not there?
Yes.
And were you there the night before?
Yes.
Are you telling the truth now, Mr. Wright?
I don't know, man. I don't know which end is up.
Well, here was my question.
Yeah.
Did you make lunch that day?
No.
But just before you told me you make all of their lunches.
I did say that. I should have said most of their lunches. When I am present, when I'm there, I make the lunches.
So be careful with very strong terms.
Hyperbolic language.
And then you said every day.
Yeah.
In the next answer, every day. Okay. Now, most of the shit a judge isn't going to care about, but it's going to get you flustered. And then when the questions come that he does care about and you're flustered.
Because you've asked the easiest questions so far. What's your name? What's your name, man? And suddenly I'm overthinking everything.
That's right.
I'm overthinking everything. And we're just on a dumb podcast.
Right. But we've role played it. You are very good at this. You really want to help our listeners. You put yourself in that role and you're picturing yourself in that role. And so here we are. But these are the type of prep that needs to happen because you can see how quickly you can get in trouble.
Because if you take these questions and you elevate them to the status of like, now we're going to be talking about your finances. Now we're going to be talking about credit card expenses. Now we're going to be talking about travel related expenses. Now we're going to be talking about like the things that I don't have even as readily on my head as my name and my carpool status. I can understand how, like, I just, listening to this, if you have ever been told that you're going to have to go to, don't underestimate this process. It's jarring.
Yeah, it's hard.
Yeah.
It's hard. But what makes clients do well in these situations is the practice.
Can you walk through, like, we're doing this kind of an example of asking how to ask questions, don't answer the statements, those kinds of things. But can you give me a sense of just how much time I would expect to spend practicing in this Depo Prep mode?
Depending on the client, I usually spend an hour going through what we're going through right now.
Okay.
Then we'll have a follow-up to talk about the substantive issues in the case.
So I get it. So first is, how do we do this? And then what?
That's right. Because now, look, we've been doing this for about 30 minutes, a little less. Do you feel right now, if I pulled out your financial affidavit, that you were going to be calm enough to go through those answers? No, you're shook.
I feel less prepared than I did when we started.
Right. You're shook. And my job is to prepare you and pump you up, not tear you down. And I do it on these simple things because that way, when we get to the hard things, it's easier. So let me give you some other things that are important to know is, I don't know is an acceptable answer.
Okay.
When's the last time you made lunches for the kids?
I don't know.
I don't know. You can't use it as a crutch on every answer to feel like you don't have to answer, because then the judge is like, he's just saying, I don't know, which means I don't believe anything he's saying.
Yeah.
Right? Can you guess? Let's do it this way. When's the last time you made lunches for the kids?
I don't know.
Can you guess about when it was?
My kid's 18. He makes his own lunches. I would guess it would have been last school year.
Okay, here we go. What was my question? My question was, can you guess? The answer is yes.
The answer is yes. Oh, God,
Yes.
Seth. This is diabolical.
Right. The answer is
Diabolical.
Yes, I can guess.
I can
Well,
guess.
why
Want me
don't
to
you guess? And then the lawyer's going to jump in and say, I'm going to instruct my client not to answer that. You don't get to guess. Okay.
Oh, man. Just when I thought I had my hand around this.
Right.
Okay. All
So
right.
don't guess at answers. If you don't know, you don't know. And give yourself wiggle room. When did you last make lunches for your kids? Approximately a year ago, maybe. Well, why don't you remember that? Because they're 18. They've been making their own lunches, I think, about a year now.
That's a perfectly legitimate point of fact. Like, that's just how it works. They've been making the lunches since they were 14, 13 years old. Like, I don't make lunches anymore.
So the point of that is you don't have to be so specific on stuff like that. Now, there's some stuff that you should know, right? When's your child's birthday?
Yeah, I know the answer to that.
Okay, good. Because you'd be surprised how many parents don't.
Okay.
Right? And they're nervous and they get it wrong. And then you put the wife on the stand and say, when's your child's birthday? And they
know
rattle it
they
off.
know right
and
there.
You're like,
right.
That's a different birthday than your husband testified to. Do you know why that is? Yes. Why? He got it wrong.
It's because he's an idiot. Because we're getting a divorce.
right. And the crazy thing is they're twins. He didn't know he gave 2 different days.
He gave 2 different birthdays. Okay. All right.
Okay. So listen to the rules. Don't ask questions of the lawyer. I don't know isn't a perfectly acceptable answer. Don't guess.
Okay.
Okay. Also, and this is the art, not a science, of depositions, is hopefully you're a good person, you love your kids. That love and fun needs to come out in court. So when you start talking about, Pete, what fun stuff do you like to do with your kids?
My son has just taken up photography, and I'm a photographer, and I love taking him out and teaching him how to make photographs.
Yeah. And you lit up when you said that. Your tone changed. You're still a little stiff, right? Because you're still in the formal setting. But when you get your clients to come out and you can see their personality and they're talking about their kids and taking photography and photos or whatever they do. And I've had the craziest answers and people are like, I can't believe you said that in court. I'm like, what's something fun that you and your child like to do? We have movie night and her favorite game is trying to throw popcorn into my mouth. And I'm really bad at catching it.
Mm-hmm.
Right.
I end up covered in popcorn and it's great.
That's right.
Yeah.
Everyone's happy. Right. And well, how does she make it where you get popcorn? And I know the answer because he's told me the story. Right. Well, at the end, she tells me to open my mouth and dumps the whole thing on my face. Like it's this fun little thing that they do. Right. And
right.
It's not an end all be all, but it gets the emotions there that are positive. Right. So it's a formal setting, but it's family law court. You're not in front of the United States Supreme Court.
Right.
Right.
Well, and you said something earlier that really rang true to me, which is this idea of that your job is to get the stories out, right? And family court, the warmth of family stories, I imagine, are central to time sharing.
And the beauty of this, if you guys are already separated and we're talking about things that happened in your house with you and your child, you can't say what she says because that's hearsay. We're not going to get into that. But you can say what she did, her emotions, this. What did she do what do you do? Well, she tries to throw popcorn into my mouth. And is it successful? Like 1 out of 100. Really? Do you keep count of that? Yes. We count him out. We keep a little scorecard. Okay. And what happens if you don't get 1 out of 100? Then she dumps it on my face. Okay. Nobody in court can bring in any evidence to contradict that.
Question. May it please the court.
Yeah.
You said I can't say anything about what she said, referring to my daughter at the time, because that's hearsay. I need to understand that because describing behavior seems to me to be the same thing as describing what I heard her say.
Oh, very, very nuanced question. Great question. You are allowed to describe what you see. You're not allowed to say in court what someone else said.
Why not?
Because hearsay is a technical legal definition, is an out-of-court statement offered in court to prove the truth of the matter asserted. Okay, what's that mean? Well, one, let's take the popcorn example. She says, Dad, what did your daughter say? I want to throw popcorn in your mouth. Okay. It's an out-of-court statement. You weren't in the courtroom when she said it. You're now in court. You're offering it to the judge to hear to prove that she really wanted to throw popcorn in your mouth. Okay? That is textbook hearsay. It's not allowed. And the reason it's not allowed is it's generally not considered credible evidence.
But me describing what she did is credible evidence?
It is, if the judge believes you. But yes, anybody can look at your observations. They're not allowed to say what other people say. There's always exceptions to this rule, and I always joke that hearsay defines itself by the exceptions. So, for example, a bank statement is hearsay. It's an out-of-court statement, literally on paper, that's being offered into court to show how much is in the account.
But that's accepted.
If it falls under the exception. And the exception is it's a business record. And generally speaking, business records are deemed correct. Right? You go to the bank, you print out your statement, you're like, yeah, that's right. There could be a mistake and you could point it out, but generally that's right. And well, okay, we got that, but is it authentic? Yes, we go get the banker to say, this is really our records. Okay. So is it relevant? Yes. So relevant, authentic, we're off on the what's called evidence stool, 3-legged stool.
Let's say because we're a fun, frolicking family, that my daughter at the time also happened to take out her phone and take a video of her throwing popcorn at my face.
Yeah.
And we have her saying, hey, Dad, I want to throw popcorn at your face. And then she throws popcorn at my face. That I can admit that, right? We can get that in. And now it's not hearsay anymore.
That's correct, because you're bringing in the video. It's not you saying it, the video is. And there's certain rules on how you authenticate a video. That's correct. Okay. Now, these are very good questions, but not what I want my client doing in a depo.
Okay.
Right? I don't want them to think that's hearsay. You can't be asking that. Okay.
But you can understand why I'm thinking it.
100%. 100%.
Okay.
Great question. Right. Very nuanced.
Okay.
Great question. And we can have a whole thing on evidence, which will definitely put people to sleep if they're listening to this. But the point of that is, I want you to be just focused on your job, and your job is to answer the question. And you don't have to worry about where they're leading you or what they're doing. It's my job to clean it up later. The other thing is, if you're being deposed, in your case, wife's counsel would ask you questions. When they're done, I, as your lawyer, am allowed to ask you questions. And then when I'm done, the other lawyer is allowed to ask you questions again. And then we're done.
Okay.
Very rarely do I ask questions at the end of the depo when you get done being deposed the first time. I'm like, they're done with their questions. I say, no questions. We're done. I'm not giving them a second bite of the apple.
You don't want them to have the last word, really.
Yeah, she still has the last word because I asked no questions, but
yeah,
I'm not giving them a second bite of the apple. In trial, it's a whole different thing.
Okay.
Any questions?
For me now, or am I in trial? Oh, I thought we were back in trial.
No. Any questions for your lawyer on Depo Prep?
I feel like what this exposes for me is that I think we need to have another conversation about taking the stand and how the rules change for me. Or do they? And in what way? And what do you want me thinking about? Because this, I feel like you gave me a very clear set of rules. Listen to the question. If I understand the question, answer the question as few words as possible.
Think about the question.
Think about the question.
Yeah, think about it. And the reason for that, you should think about it anyway. But it also gives your lawyer an opportunity to go through. Oh, there's a Rolodex of objections. Because once you answer, I can't bring my objection. It has to be right away. That's why you think about your question for just a minute.
Okay, right? That's a really great tip. That's a really great tip. So I have to think about the question. Okay, take a breath. Think about the question. If I understand the question, answer in as few words as possible, and then shut the fuck up.
Mm-hmm. Same in court.
I mean, I think I screwed up almost every one of those examples today, but I do think I understand it better.
Right, but now if we go through it, you're not going to be as stressed about it because there's simple instructions. There's simple steps.
Yeah, it's simple, not easy.
That's right.
Right? That's important.
Unless you practice. A couple other things, and then we'll wrap it up. Use your child's name.
Okay.
Don't say my kid. Right? And if you have to say our kid, that's better than my kid. Because when you say my kid, judges will hear that as possessive. It's my kid, not hers.
Right. Give the kid an identity that's unique to themselves.
That's right. And it's hard because we say my kid all the time.
Yeah. Right.
The other thing in trial, look at the judge.
Me?
Yeah, whoever's on the witness stand. When you're answering, look at the judge.
Okay.
That's who you're trying to persuade. Right? If the judge is off to your right and you're looking straight at the lawyer and you're talking about how much you love your kid, why don't you look at the judge? Let him see it.
Yeah. You do a lot of Zoom trials. What do you have? Is there a recommendation to give yourself a look at the judge vibe when you're on Zoom?
No, that judge has got you pegged on Zoom. We haven't had as many recently, but all good questions. So check with your local lawyer in your jurisdiction. If you have depos coming up, trial, ask them for prep.
Okay.
So how do I answer these questions? What questions do you expect that I will be asked? Sometimes we role play it where we'll have a lawyer come in and ask you questions, and then the other lawyer is going to do cross and really try to hit you hard. Okay? Because we try to formulate, hey, what's the other side going to do? How are we going to be prepared?
Yeah. It goes back to debate prep, man. Top prep. That's it. Yeah. What do you recommend? The day before, the week before? How much time do you give for prep?
Oh, no. Like, I don't like to do it too early. So, a week or two before, depending on the complexity of it, sometimes a month before, and then we revisit it. But you can tell it's at least more than one session, depending.
Yeah. Oh, I totally get that. Oh, this is fascinating. I'm glad we did this. This is certainly helpful for me, and I didn't get to say objection once, but now I know what objection hearsay means, and I'm very excited to use that.
That's right. Yeah. And, well, you know that I have teenage kids. Some of them are older, in their 20s now. The youngest, sometimes around the dinner table or we're just walking around, his mother will ask him a question, and he'll say, objection relevance.
Noted.
And my favorite objection that he says is, objection, you're on a need-to-know basis.
Sustained. Outstanding. Yeah. This was good, Seth. This is useful. I hope a lot of people get something out of this experience.
Yep.
Go
Sounds
through it.
Good.
Thank you, everybody, for downloading and listening to the show.
And Pete,
you have something else? Yeah.
Before we close out,
yeah,
you were a very good client.
Oh, thank you.
There you go.
That means the world. All right. Thank you, everybody, for downloading and listening. You are a very good audience, and we sure appreciate your time and your attention. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll see you next week right here on How to Split a Toaster, a divorce podcast about saving your relationships.
How to Split a Toaster is part of the True Story FM podcast network, produced by Andy Nelson, music by T. Bless and the Professionals and DB Studios. Seth Nelson is an attorney with NLG Divorce and Family Law with offices in Tampa, Florida. While we may be discussing family law topics, How to Split a Toaster is not intended to, nor is it providing legal advice. Every situation is different. If you have specific questions regarding your situation, please seek your own legal counsel with an attorney licensed to practice law in your jurisdiction. Pete Wright is not an attorney or employee of NLG Divorce and Family Law. Seth Nelson is licensed to practice law in Florida.